No, I was
All right.
no, I was
So I'm gonna-
I was stealing the watch.
Right. He gave the
I was stealing the watch. I gave him his cable back.
yeah, so the watch is
The watch was
the
stolen.
value.
Yeah, the watch was stolen. I was stealing the watch. I gave him his cable back. I was proving to do that I could get his cable.
That's not what he just said, though.
Yes. I was proving to do that I could get his cable. And I wasn't talking about the watch. I was talking about the cable. Because the cable is what I proved that I could get his cable off of his neck. Because he had his cable, his charging cable I got off his neck, the dude at the Verizon wireless store. He had the charging cable around his neck.
So, sir,
No, I'm not. This is not.
He got the charging, he had the charging cable around his neck.
Mr. Bash,
I pulled the,
what did I just say?
okay, I pulled the watch off.
What did I just say? Upfront jail. However, did you go through the sentencing judge waiver with your client?
I have not, Your Honor. I realize now that he's going to be sentenced in 14B. I'm
You'll
assuming.
be sentenced in front of Judge Washington. I'll go through that in the plea.
I apologize, Your Honor.
All right. I am just going to check that box on the form.
Absolutely.
That is correct.
All right. May I have the defendant's sworn?
Raise your right hand. Solemnly swear to affirm the testimony you're about to give will be the truth, but the truth. God, state your name.
Cyrus Robertson.
Has he, did he execute an advice or rights form?
I believe he had, Your Honor.
I don't have one.
I can get another one. Let you off tomorrow. No, just for the record, I have went over these rights with my client. He does understand them.
Just
Ms. Wellingberg, this is a further indication of whose fault it is.
Rest. What was the rest of the
9-3-4.
Take full responsibility, Your Honor.
Sir, it is this court's understanding that you are going to be pleading no contest to the charge of child abuse 4th degree. Is that your understanding?
Yes, Your Honor.
That is by up to 1 year incarceration and up to 5 years probation. You understand that?
Yes, sir.
All right. Do you understand what a no contest plea is?
Yes, sir.
All right. 2 things about it that I have to make sure that you understand it. First of all, it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
The second thing you need to understand is that for purposes of sentencing, the court is going to treat you the same as though you had pled guilty. You understand that?
Yes, sir.
And you understand, sir, that you'll be sentenced before Judge Washington in 14B District Court, although I'm taking your plea.
Yes, Your Honor.
Basis for the no contest plea.
Civil liability, Your Honor.
All right. Sir, to that charge, how do you plead?
Guilty.
Nope. Okay.
Really?
Oh, no contest. I'm sorry.
You understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
All right. You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
Voluntarily and of your own free will? Court has been handed and has reviewed Washington County Sheriff's Office report for their case number 25-82392. Any objection to the court having reviewed that report?
No objection.
No objection, Your Honor. The people or the defense would stipulate to the police report for factual basis, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to apprise you that upon my acceptance of your plea, and if between the time of my acceptance and your time of sentencing, if you commit misconduct as defined in the Michigan court rule, you would not be entitled to withdraw your plea, and the judge would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this trial?
None, Your Honor.
All right. And have I complied with the court rule?
Yes, Your Honor.
Court will accept the defendant's plea of no contest to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
July 2nd at 10 a.m.
July 2nd, 2026, 10 a.m. before Judge Washington. Bond will continue.
Thank you, Your Honor. Great to see you. I appreciate you letting me slide with the lack of the signature.
No,
You were easy on me today. I gotta tell you.
no,
Not-
you'll pay for it later. All right, take care. Court calls the case, People versus Nicholas Strunk.
Attorney for the people, Your Honor. Morning, Your Honor. Sam Bernstein with and on behalf of Mr. Strunk. Mr. Strunk, could you state your name for the court?
Nicholas Strunk. This is a waiver.
Yes, Your Honor. We've had some plea resolution discussions.
All right. Sir, you're waiving your right to a preliminary examination?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand that you will not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor. And there is, although not finalized, arrangement in this case, defense counsel and I have been in session and we have negatively will be entered.
A hide a plea.
Yes.
Preliminary examination having been waived, defendants bound over to circuit court on all three counts.
Your Honor, we ask the court to please waive reading and continue not guilty plea. And if I could address one bond issue at the appropriate time.
And having waived formal reading, he's standing mute at this time.
Yes, Your Honor.
Standing mute, court will enter a not guilty plea as to all three counts. Pretrial will be set for
July 13th at 1:30 with Judge Hamud.
July 13th, 2026, 1:30 before Judge Hamud. Yes, as to bound.
Mr. Strunk right now has a home confinement tether on. A couple things about this case, Your Honor. We are headed towards a resolution, and I'm almost positive it's going to resolve. This is the second time that we've been here for this case. This case had previously been in.
I'm not removing, I mean, I'll let you finish, but I'm not removing the home confinement tether. He's facing a life offense. This is a capital law capital. So
I was actually just going to ask for it to be switched to a GPS tether rather than home confinement. So not to remove the tether from his leg. No objection with that, Your Honor, but the housing situation that he has can sometimes get unstable with where he's staying, and it would make life a lot easier. He's had absolutely no contact with the complainant since the last case was dismissed and throughout this case.
people.
Your Honor, absolutely, this is a life offense, one that the court would be well within its right to on outright. I would just ask that it's out of me.
Motion for bond modification is denied. Bond will continue with the home confinement. Thank you.
Yeah. Mayor, approach to sign the information.
Court does call the case, People versus Ashley Albert. Oh, boy.
Good morning, Your Honor.
Morning.
Christina Costantino, appearing with and on behalf of Ashley Albert. Ashley, can you state your name for the court? Ashley Albert.
Court has before it a plea form that indicates that the defendant is going to be pleading no contest to an added count 3 of larceny, 200 to 1,000. That's a 1-year offense. On a successful plea to that, count 3, counts 1 and 2 would be dismissed. Defendant is agreeing to pay restitution in the amount of $2,770. And that's the court's full understanding.
That's correct, Your Honor.
As
Yeah, I have her sworn.
Right hand. Do you solemnly swear and affirm the testimony you're about to give truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name, please.
Ashley Albert.
Ma'am, it is this court's understanding that you are going to be pleading contest to the charge larceny 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine. Court cost, the fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes.
All right. You understand what a no contest plea is?
Yes.
2 things about it I have to make sure that you understand. First of all, it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
The second thing is is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
You understand also, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court.
Oh, yes.
Basis for the no contest plea?
Potential civil liability.
Ma'am, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up right.
Yes.
Are you on probation or has anybody promised you anything other than what's been stated here today to get anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will. Court has decided and has reviewed as soon as I get to it. And has reviewed Michigan Department of State Police report for their case number 24-25. Any objection to the court having reviewed that report?
No objection, Your Honor.
No objection, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis. The court could determine the defendant's guilt of this offense. Ma'am, I do have to advise you that if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, ma'am?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people?
None from the defense.
And have I complied with the court?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of no contest to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be June 2nd, 2026, 10 a.m. before Judge Barr. Bond will continue.
Very much, Judge. With that, I'm out of chair.
You're done?
Hey.
Oh, always a pleasure.
Thanks, Judge.
Take care. Court calls the case, People versus Jason Bryant.
Good morning, Your Honor. Gloria, Assistant Public Defender with and on behalf of Mr. Bryant, who is approaching. Mr. Bryant, can you state your name for the court?
Jason Bryant.
All right. And he's waiving his right.
He is, Your Honor. If I may put the offer on the record.
Go ahead.
The people are offering a use in this matter, but Mr. Bryant has a pending violation of probation that's already set before Judge Conlon on June 17th. So I specifically asked the people to hold that offer open until his VOP in front of Judge Conlon, when we would seek a global resolution for both matters.
That is
Sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a hearing where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you'll not have a hearing on that? You'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
All right. People also waive their right.
yes, sir.
Preliminary examination haven't been waived. Defendants bound over to circuit court on both counts.
We would waive formal reading and stand mute, Your Honor.
Defendant every way from a reading standing mute. Court will enter not guilty plea. Pretrial in this matter will be set
June 3rd at 1:30 with Judge Conlon.
June 3rd, 2026, 1:30 before Judge Conlon. We'll continue.
Thank you, Your Honor.
All right, thank you.
Court calls case People versus Cynthia Holloway.
And Lori Yagi, Assistant Public Defender with and on behalf of Ms. Holloway. Could you state your name for the court?
Shantia Janaya Holloway.
Thank you.
Your Honor, may we approach in this matter? Briefly, very briefly.
I have already this request from.
You're joining in it? And my, that there is some additional evidence which aware upon this, the setting of this preliminary exam date. And that there's a request to adjourn. Is that correct, counsel?
That's correct, Your Honor.
Preliminary examination will be in person, will be adjourned to, where's my calendar?
May 26th.
May 26th, 2026, 9 a.m. before me. Do you wish to make a request? You may go ahead.
Your Honor, we're grateful that we're able to come back next week. I think my bond motion would be stronger once I had more information. And so I think given that we're able to come back next week, which we're grateful for, I'll address it at that time.
Very good. Bond will continue with its issues. Thank you. Do I not have anything else?
I believe that we are ready.
Why is Bellinger giving me the peace sign?
That means I'm ready on two.
Oh, I didn't know what that was. I didn't know if he was gonna start something or what, because I didn't know if it was a peace sign, a gang sign. I don't.
The two being Cooper and Pecos.
That's correct.
Okay. So there, this is no longer.
This one.
Yeah.
Is no longer. What's the other one doing?
We gotta do it.
Oh,
I need to call for,
can I do the other one then?
they're both in custody.
Oh, no. Mind. I do see the purple tabs.
Okay.
Come on. It's okay. No, it's no. No. So,
Um.
no, it's just here.
So. We don't want to call that.
No, that's this one.
That's that one. Okay.
Your Honor, do you have time for me to approach real quick on an unrelated matter?
Yes.
No. Yes, come on. Oh, no.
Morning, Your Honor. Raymond Cook for the people in the files 1997 and 048. And Assistant Public Defender Jay Bellinger on all of them.
Okay.
Mr. Cooper, can you please state your name for the group? Okay. I'm working on getting you that discovery. I might have to meet you and lock up for that. In Your Honor, date and time set for preliminary examinations today. I will let Mr. Cook take it away. 997.
Said 1248.
0248.
Yes. Oh, I'm sorry. People being unable to proceed in those matters. Case is dismissed. That's on defendant's motion.
0, 7. We're at remand. We're
I'm sorry.
unable to proceed on the felony count today. We're asking the court to remand in the district court on a added charge of on second offense. And provide an amended.
Thank you.
I can't object, but there's not much you can really do about that. So
All right. Count 1 will be dismissed. I'll continue the defendant's not guilty plea. Upon the presentation, you waive presentation and
we do, Your Honor.
no complaint.
We do.
All right. 2-0. Pre-trial in this matter will be set
June 4th at 9 a.m.
June 4th, 2026, 9 a.m. before Judge Barr.
And Your Honor, if I may address bond briefly.
You may.
Mr. Cooper is being held currently on a parole hold, also on the bonds for these matters. I am asking consideration for a PR so that he may handle those matters out of Wayne County. So we can start getting those taken care of as he awaits.
But he's on parole.
I'm sorry, Your Honor, he has Wayne County cases. It's not parole. He's got Wayne County case as a violation on on his probation over there as a result of these matters. Am I correct in that?
Okay, so there's no parole hold
Correct.
as, all right.
And he would obviously just be taken over there if you were to give him a PR on these. That way he can start handling those matters.
Right, but then my problem becomes. Go ahead. Ms. Tanner.
Concerned in this situation, this defendant does in fact have cases in Wayne County. He's essentially engaging in the same behavior there. Hit with domestic violence there, transaction device, charges, arrests. He pled in our jurisdiction to a domestic violence third offense in 2024. Continued his criminal activities, and then here we are now. And I understand that we had to remain the domestic violence second offense. That does not take away our concerns for this victim or the community at large. In this case, Your Honor, the victim initially was very hesitant to report. It was really her parents that pushed it forward, being concerned for her safety. And it was because of ongoing threats to not only her, but her family that she was in a point where she reported the matter. That has such a lengthy history, we still have the same concern because we did at the same bond mistake.
Anything else, Mr. Brown?
Nothing that I haven't already stated, Your Honor.
Court would still consider the defendant a risk to the public and therefore would deny the request to change his bond, and this bond will continue. Thank you.
Your Honor.
Thank you. Pardon? They're gonna grab, okay,
One time though.
what are we doing?
I got a wheelchair coming through next, just to let everyone else.
I don't know what that means. Court does call the case, People versus Cameron Larry.
TP.
Morning, Your Honor, Rachel, Assistant Prosecuting Attorney on something.
Thank you, Your Honor. Alex Boren Green on behalf of Mr. Larry. Mr. Larry, could you state your name?
Cameron Larry.
What are we doing?
All right, who's the folks?
Yes.
Your Honor.
Thank you.
Court calls the case, People versus Michael Payton.
Verbal record.
Wheelchair coming through.
Payton, can you hear me, sir? Good. Can you hear me, Mr. Payton?
Yes, sir. Yes, sir.
All right.
Did you, I'm sorry, Your Honor, did you call the case?
Oh, yeah,
Okay.
about like an hour.
Okay, Assistant Public Defender, Felon on behalf of Mr. Payton, who appears. Mr. Payton, can you please state your name for the record?
Paul Payton.
Thank you. He's waving.
Is, Your Honor, there is an offer. I'll have Ms. Willenbrink put on the record, and then we would just ask to address bond when appropriate.
Yes, Your Honor, I did offer in this case to waive the plea to added count 3 and 4 of criminal sexual conduct in the fourth degree, contrary to MCL 750.520E1G. That's a 2-year life for misdemeanor and $500 in exchange at sentence counts 1 and 2.
And that is our complete understanding of the offer at this time, Your Honor.
All right, Mr. Payton, you're waiving your right to a preliminary examination? Need you to verbalize it.
Yes, sir.
All right. You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them. You understand you will not have that hearing and that you'll proceed to circuit court for further resolution. All right, for the record, people also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on both counts.
Your Honor, as to that, we would acknowledge receipt of the information, waive formal reading, stand mute at this time.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
First at 1:30 with Judge Hamud.
June 1st, 2026, 1:30, Judge Hamud.
And then as to bond, Your Honor,
Yes.
I have spoken with Ms. Willenbrang. My understanding is that we would stipulate to this. I will let her speak for herself. However, Mr. Payton has been in the jail for the last 51 days. He advises that he does have the financial means to place himself at the same motel that he was staying at prior to his arrest. He is willing to be placed on home confinement with GPS tether at that location at release. He's got no criminal history. And this is the only matter holding him. His bond is currently set at $25,000. No objection to any other bond conditions that would satisfy the court for purposes of his release. And he does understand, we have duly talked about what he has to lose here by violating any of the prescribed conditions. So we would ask for his release on PR with home confinement.
Sure, I did discuss this with the feds and I said that I did not have an objection to a home confinement tether. You would just need to provide the instructions with that address. I believe that that motel is fine. It's not where victim or her family are staying, but do we have the address for that?
What motel were you staying at, Mr. Payton?
Monroe Hotel.
Monroe Motel?
Yes, sir.
All right. Well, since there's not an objection, what I would do at this juncture, I think, is continue the bond. If you can get an order over to me today, I'll sign off
Okay.
on it. That's stipulated, because it sounds like you're not in disagreement. It's
Okay.
just a matter of getting the location.
Okay.
All right.
And you're certain about that motel name so that I can look up the address for it?
Yeah, I have
Okay.
it in my room.
That's okay. All right. I will talk to you about that a little later, okay? All right. Thank you, Your Honor.
All right.
Yes.
We can. I know. Do we have one? I don't know what Alan's doing, so come on all the way up. No, go, okay, man. I'm just saying. Didn't know where you were, Miss Willenberg. Had to walk all the way up here. No, I don't know, man. So I gave you that one back.
Yes, I took it.
And then there's other one you were talking about, the hallway.
Yeah, Mr. Down the argument, but so I still don't see them.
Okay.
That it's the. You're right. Right.
Yeah, that's great.
What are you? Yeah. I want to tell you this. We are.
Court does call the case People versus Patrick Rowe, 2 cases. Wow. Oh, well, I'm gonna ask you to take him back because Mr. Warren Green is not gonna be out of this conversation yet. So, thank you. Court does call the case of the People versus Thomas Fasher, 2 cases.
Motion for retrial on behalf of Mr. Vassar in case ending 1002. And Assistant Public Defender Ben Dunaway on behalf of Mr. Basher in the case ending in 5772. Sir, would you please state your name for the record?
Thomas Basher.
Thank you. What are we doing?
In 1002, it's my understanding that people are not able to move forward in that case, and based on that, I would be asking for a bond motion, a brief bond motion, Your Honor. Your Honor, it's correct that we cannot proceed with the felony counts. We'd ask for a remand to district court on this.
So you cannot proceed on counts 1 and 2 and would remand on 3.
That's correct, Your Honor.
Granted dismissal on counts 1 and continue the defendant's not guilty plea to count 3. Pre-trial in this matter will be set
June 1st at 9 a.m.
June 1st, 2026, 9 a.m. before Judge Washington, excuse me.
I'm sorry, Your Honor, I'm sorry.
June 1st, 9 a.m. before Judge Washington.
Thank you, Your Honor.
As to bond,
Your Honor, in this case, I believe the defendant's bond is $1,000, 10%. The people have not been able to proceed on counts 1 and 2. We would be asking for a personal Ricardo's bond. The defendant's guardian is here and has expressed to me that she would be working to making sure that he abides by all terms of his bond and that help him secure housing in this matter. So therefore, we'll be asking for a PR bond, Your Honor. Your Honor, we're going to leave it to the court's discretion with any case involving domestic violence. We do have, of course, concerns. Who's not present here today, but understanding is being remanded.
and I'm not opposed to necessarily changing the bond, but he'd have to be interviewed by probation prior to the court doing that. So you can bring that before Judge Washington. I'm going to continue his bond at this time.
All right, thank you, Your Honor.
Your Honor, in the case ending in 5772, we do have a plea.
Plea form in this case indicates that the defendant will be pleading to an added count 3 of larceny less than $200 to 93-day offense. Lesser plea to that added count 3, counts 1 and 2 would be dismissed. Defendant agrees to pay full restitution on all counts. Court's full understanding.
That's correct, Your Honor.
That is correct, Your Honor.
I have him. Oh, want to say something, sir?
Yeah, I was gonna ask you, if at all possible, can I get my phone privileges back so I can call my family?
We got to deal with the plea, then we can address that stuff afterwards. It's just one thing at a time.
I haven't sworn.
Right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. State your name.
Thomas Basher.
Sir, it is this court's understanding you're going to plead guilty to an added count 3 of larceny less than $200. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court cost. The fine could be increased to 3 times the value of the property taken. $100, that would become the maximum fine. Do you understand that?
Yes, Your Honor.
All right. You also understand, sir, that while I'm taking the plea, I would not be your sentencing judge, and you would be sentenced before Judge.
Yes, Your Honor.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead? You understand that by pleading guilty, you'll not have a trial of any kind. You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding those rights?
No, Your Honor.
Please look at paragraph 5. You see a copy there. Those are your rights which are part of a trial. You understand by pleading guilty, you're giving up those rights as well as all the rights in that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Go on probation or parole?
It's this case.
No? No. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
anybody threaten you or coerce you?
Oh, yeah.
You're doing this voluntarily
Yes, sir.
and of your own free will? Because you believe that you are indeed guilty?
Yes, sir.
May 9th, 2025, at the location of 3035 Washington Avenue, City of Ann Arbor, Washington County, State of Michigan. What'd you do at the Verizon wireless store that makes you think that you're guilty?
I took a watch off the wall, charging cable.
Took a what?
A watch off the wall and a charging cable. I asked if I could use the charging cable, and I left the building with it and then brought it back to him. I just proved to somebody that I could take it from him and give it back to him. It was basically like a YouTube hoax, but he got it back.
Can I ask a question, Your Honor?
Took it out of the store, and then brought it back. So when you initially took it and left the store, were you intending on taking it and keep? No, can't take his plea. I don't have the requisite intent for a larceny. So
We're gonna schedule this for exam again.
I don't get it. What was that?
Are we ready to stay, or did you
No,
please quit?
Hold this.
Got it. I understand.
Watch and just.
No, I was.
All right.
No, I was.
So I'm gonna-
I was stealing the watch.
Right, he gave the.
I was stealing the watch. I gave him his cable back.
Yeah, so the watch is.
The watch was
the
stolen.
value.
Yeah, the watch was stolen. I was stealing the watch. I gave him his cable back. I was proving to do that I could get his cable.
That's not what he just said, though.
Yes. I was proving to do that I could get his cable. And I wasn't talking about the watch. I was talking about the cable. Because the cable is what I proved that I could get his cable off of his neck. Because he had his cable, his charging cable I got off his neck, the dude at the Verizon wireless store. He had the charging cable around his neck.
So, sir, no, I'm not, this is not.
He got the charging, he had the charging cable around his neck.
Mr. Bash,
I pulled the,
what did I just say?
okay, I pulled the watch off.
What did I just say? I'm not taking your plea. I'll put it out a week, talk about it, come back, and if there can be a clean plea, I'll deal with it then,
Okay.
but I'm not gonna do it this way.
Same one, and I'll say the same thing next time.
Your Honor, Mr. Vasher briefly mentioned his phone.
I'm gonna, yes, hang on.
Okay,
Preliminary examination in the 15th District Court matter. I'll reset it to next week, the 20th. To May 26th, 2026, 9 a.m. before me. Yes, Ms. Scratch, I don't have that file anymore.
I'm sorry, Your Honor.
Next week you'll have 89.
Go ahead.
It's my understanding that Mr. Vasher does not have phone privileges. He needs to make arrangements with his guardian upon his release for housing, and his guardian needs contact with him so she can arrange that. That's why we're asking for phone privileges back, at least to speak to your guardian. Is that correct?
That-
And
Yes, Your Honor.
and so she needs to be able to talk to him to arrange housing and things of that nature, make sure he's doing okay.
Go ahead, anything from the people.
I'm gonna use the court's discretion. This is in person. This has been brought up by previous concern was that guardian is someone who approached us, had not spoken to police about the domestic violence case, has seemingly been constantly victim of that case. So I had concerns about there being contact with Basher and his sister, who's the guardian, given her contact with the victim of his.
I would have the same concerns. I'm not gonna change anything. That, after he's interviewed, then I think all of that can be addressed.
Okay,
Thank you.
thank you. Or to. Oh,
We had probation.
Set up a no contest.
right.
Please.
Okay. So Mr. Warren Green is still, yeah, that's okay because I know he's involved in a conversation.
I just passed the whole.
Did he look like he was walking in circles?
Termination in a straight line. Try to really.
He's doing a lot of that today. Why don't I stand in recess? Because he's gonna have to deal with something and then those two are his. No, I'll let you figure it out. Or it's gonna, or to stand in recess.
All rise.
Say again.
In this bizarre courtroom moment, a defendant completely confuses the judge after trying to explain why he pulled a watch and charging cable off another man during an argument. At first, the defendant shockingly blurts out, "I was stealing the watch." The courtroom immediately goes silent. But seconds later, he starts backtracking and insists he was actually only trying to prove he could remove the man's charging cable from around his neck, not steal the watch itself. "I was proving that I could get his cable." The judge becomes visibly frustrated as the defendant keeps changing his story mid-sentence and mixing up the watch, the cable, and what exactly happened inside the Verizon store. That's not what you just said, though. Things spiral even further when the defendant suddenly interrupts again, trying to clarify himself one more time. "The watch was stolen. I gave him his cable back." The judge finally cuts him off completely as the courtroom turns into total chaos over one of the strangest explanations anyone has heard all day. Do you think nervous defendants accidentally make things worse by talking too much in court?